Every week, every Friday, we like to end the week with Entrepreneurship and the Law. And if we're talking about entrepreneurship and the law, we're talking to Mark Furman of Tarlow, Breed, Hart, and Rogers. Welcome back, Mark.
Hi, Jeffrey. Great to be with you today.
Thank you very much, Mark.
I wanted to talk about a case involving Tesla Motors.
Oh, yes. I know some people with those cars.
The electric car company that has an interesting model, different than every other manufacturer that I know of in the world. Tesla sells cars directly. It has a manufacturing company, and then it sets up companies that are wholly owned subsidiaries in different states, and they don't use a dealer system.
Right.
So General Motors, Toyota, Subaru, etc., Honda, they all have dealers.
They've cut out one layer of margins.
Correct. So needless to say, from the perspective of dealers, Tesla's model is very controversial.
Right.
And in Massachusetts, other than Tesla, we have dealer networks, and dealers have been successful in getting laws passed to protect themselves from some actions that they view as oppressive or unfair on the part of manufacturers to them. And there's actually a law that's been called the Dealer's Bill of Rights, certain things that are considered illegal and that manufacturers can't do to dealers. However, with Tesla coming into Massachusetts, they opened up a gallery, not a dealership, but a gallery at the Natick Mall. And the Massachusetts State Automobile Dealers Association and a couple of other dealerships brought a lawsuit claiming that it was illegal under Massachusetts law to use a showroom and whereby, in effect, the manufacturer was directly selling Tesla vehicles to the public.
And were they, I don't know if you know the answer, were they selling from this showroom, taking orders?
They allege no, that the purpose was just to educate folks about the electric cars and Tesla in general. But
a little bit of a shakedown going on.
But the dealer plaintiffs said, wait a minute, that's what we do in our dealer showrooms. We show vehicles that are designed to look attractive and to generate an interest in, and it's designed to facilitate sales. There'd be no other reason for having the gallery. So the case turns on, do they have standing to fight with Tesla? And the court said, no, they don't. This is not the type of problem that the law was designed to address. You can't be, you're effectively a stranger to Tesla manufacturers. Now, the plaintiffs claim it's unfair competition, and I think you hit the nail on the head, Jeffrey, because you eliminate a layer in the distribution process. You have a cost advantage if you can do that. But Tesla is ahead of, I guess, some of the traditional manufacturers.
They have a competitive cost basis in the marketplace.
Right. They seem to have very substantial capital to pursue the development of their product. They don't have some of the legacy costs that the traditional manufacturers have in terms of, labor and pension and health insurance and all of that. So anyway, so the court sided with Tesla Motors, threw the case out, and didn't even reach the merits of the case in a sense, because they just found there was no standing by the plaintiffs. But it's not clear to me that anybody would have standing